Welcome to the online lecture on copyright laws. In previous sessions of copyright law, we discussed the various rights under copyright law and what is infringement of copyright. And that brings us to today's topic of discussion, that is remedies under copyright law. So today's topic of discussion is remedies under copyright law. Remedies are the compensation which is assured and given to the copyright owner whose right has been infringed. So they are the compensation which is given to the copyright owner when his rights have been infringed. So there are two types of remedies under Copyright Act. The first is civil remedy and the second one is criminal remedy. Let's understand what is civil remedy. Section 55 of the Copyright Act talks about civil remedies. It talks about when copyright in any work has been infringed, the owner of the copyright shall be entitled to first injunction, second is damages, and the third one is accounts for profit. So when any copyright is infringed, then the owner can claim civil remedy, and the first civil remedy is injunction, to put a stay on the infringing activity then and there. Second one is to claim damages, whatever they have produced, the infringing copies or any work, that will be given back to the copyright owner. And the third one is accounts for profit, that is whatever profits the infringer has made out of selling the copyright protected work, that profit would be given back to the copyright owner. However, there is an exception to this. If the defendants are able to prove that at the date of the infringement they were not aware of any copyright that is subsisting over the work that they are using, then the only remedy that the copyright owner is entitled is either injunction, to put the stay over the infringing activity then and there, or to get part of the profits that they have received so far by selling or by making use of the infringing work. So this is civil remedy that is discussed under section 55 of the Copyright Act. Now let's move on to the criminal offences. The criminal remedy, that it starts from section 63. So section 63 talks about, first, it is a basic infringement. So when an infringement of a copyright is done, then the minimum punishment, that is of imprisonment, is of 6 months, and that imprisonment may extend up to 3 years, and the minimum fine that is to be given to the copyright owner is of rupees 50,000, and that the minimum fine may extend to rupees 2 lakhs. However, there is an exception here as well. When the defendants are able to prove that the infringement were not done for the commercial gain in the course of trade or any business, then the court may do, the court may impose the punishment, and the punishment would be less than 6 months, or the fine which the court might impose, the fine would be less than 50,000. So section 63 talks about infringement of copyright. Now let's move on to section 63A. This talks about when the person who has been convicted under section 63 before is again convicted, has again committed the copyright infringement act and is convicted again. So that person would be dealt under section 63A. So for the second and subsequent offence, when anybody who has first been convicted under section 63 is again committing the crime, the minimum imprisonment for that person would be of 1 year, and the minimum imprisonment is of 1 year, and that may extend to 3 years, and the fine would be not less than 1 lakh rupees, and it may extend to 2 lakh rupees. So the maximum imprisonment and the maximum fine is same in section 63 and section 63A. However, the minimum imprisonment has increased up to 1 year in 63A, and the minimum fine has also been increased from 50,000, that is there in 63, to 1 lakh rupees. So this is for the second and the subsequent offence if the person that has already committed offence first under section 63 and he has also been convicted under section 63, then only section 63A would apply. Now let's move on to the another section. This talks about when any computer program is infringed. So when anybody is using an infringing copy of a computer program, that person who has committed the act of infringement of any computer program would be punishable for the imprisonment, and the term would be not less than 7 days, and it's very surprising that the maximum would extend up to 3 years. So here the minimum is 7 days, but the maximum imprisonment may extend up to 3 years. And the minimum fine here, when a computer program is infringed, so the minimum fine which the infringer is supposed to give is of rupees 50,000, and that may extend up to rupees 2 lakhs. So this is 63B. It talks about infringement of a copyright program. However, here as well, if the computer program was infringed and was used not for any commercial gain in the course of trade or any business, then the court, what they can do, the court may not impose any sentence in that circumstances. They may not impose any sentence of imprisonment, and they may only impose a fine, and that fine can be up to rupees 50,000. So when the computer program, although is being infringed but not for some commercial gain, but if it would be under fair use, which we discussed under section 52 of the Copyright Act, then the fair use of a computer program is done, then the person would not be given imprisonment, and he may only be fined, may be asked to just pay fine of rupees 50,000 rupees. That is the maximum amount. So we discussed 63B. Now let's move on to another section, section 65. This talks about possession of plates. So possession of plates for making infringing copies. When I have the complete knowledge as to why I possess the plates for making the infringing copies, then the imprisonment would be for 2 years, and the person would also be liable to fine. Here the fine has not been fixed, the amount of fine has not been fixed, nor the minimum, neither the maximum has been fixed. It depends on the matter and facts of the case, and it varies from case to case. So section 65, possession of plates for making infringing copies, and what is the most important thing here, that the person should have complete knowledge as to why he has possessed those plates for making infringing copies. Then the imprisonment would be for 2 years, and he shall also be liable to fine. Then section 67, this talks about making of false entries. So when anybody who is making false entries in the register is caught, and then he may be punished with imprisonment that may extend to 1 year or with fine or both. So here also the fine has not been fixed, and it depends on, and it varies from case to case. So section 67 talks about making of false entries in the register of copyright. So whenever any copyright is being given, that particular copyright protection, the term of copyright, the name of the owner of the copyright is written down in a register, that is the register of copyright. So if anybody is caught making false entries in that register, and then he may be punished with imprisonment, and that may extend to 1 year or with fine or both. Now section 68, this talks about making a false statement or representation. So if anybody makes false statements or representation, and he has the knowledge that whatever statements or representation he is making is false in nature, and he is making those statements in order to deceive or influence any authority, then that person would be punished, and he would be imprisoned for a period which may extend to 1 year or with fine or both. So under section 68, this talks about making of false statements or representation knowingly with complete knowledge in order to deceive or influence any authority. Then the person would be imprisoned, and the imprisonment may extend up to 1 year or with fine or both. And in this case as well, under this section as well, the fine has not been fixed. Only thing that is fixed is the maximum amount of imprisonment, maximum sentence of imprisonment, that is a 1 year, and the fine would vary from case to case. Now section 68A, this talks about whoever publishes sound recording and video films. So this talks about infringement of sound recording and video films. So whoever makes infringement or publishes sound recording or any video films without the permission and in contravention to section 52A shall be punished with imprisonment, and that imprisonment may extend up to 3 years, and he shall also be liable to fine. So anybody who is infringing any sound recording or any video films of a copyright owner without his permission, obviously then only he is infringing. So without permission and in contravention to section 52A, he shall be liable with imprisonment, and the imprisonment may extend up to 3 years. So here what do we mean when we just say that the imprisonment may extend up to 3 years? This means that the maximum imprisonment in case of if anybody is convicted under section 68A is of 3 years, and the minimum is upon the judges to decide, is upon the authorities to decide. So the minimum can be of some days, some months or some years, but the maximum that the authorities can give to any convict under section 68A is of 3 years, and shall also be liable to fine. So in this under this section as well, the fine has not been fixed, and it will vary from case to case depending upon the facts and the circumstances of the case. So it is upon the judges to decide what is the right amount of fine that should be imposed upon the person, upon the convict under section 68A. Now this is section 69. This talks about when the offence of copyright infringement is committed by a company. Now before I begin this section, let us understand this one simple thing, that in companies law, under companies law, the basic thing, the major thing is that company and the members involved in a company and the members of a company, both these are separate entities. So there are two separate entities. A company is an entity in itself, the name and the building and the structure and whatever is there, the credentials of a company, it is a separate entity, and all the members of the company are separate entities. So if any wrong is committed by a company, there can be circumstances when only company would be punished and not the members. So the amount of compensation that would be taken out would be given from the accounts of the company itself and not the personal accounts of the members. So before we plunge in, we just need to understand this, that under companies law, the company and the members of the company, the higher authorities, the members, the CEO, the director of the company, there are two separate entities. So now let us understand what is section 69. When any offence under this act, that is Copyright Act, is committed by a company, every person responsible for the same as well as the company would be held liable and be punished accordingly. So if a copyright infringement act is done by a company, then all the persons involved for the copyright infringement as well as the company, since both these are separate entities, so all the members of the company that is involved in the copyright infringement and the company itself, both would be held liable and they will be punished accordingly. Here neither the imprisonment is fixed nor the amount of compensation, amount of fine that is to be paid is fixed. It varies from case to case. It depends on the facts and circumstances of the case. But here as well there is an exception. Say if any person in charge is able to prove that the offence was committed without his knowledge. For any offence to be committed, for any person to be convicted, it is necessary that he should have knowledge of the act. In the previous sections also we have discussed that if anybody is able to prove that he did not have the knowledge about the same, then he would not be held liable and he would be given lesser punishment. So here, if any person in charge is able to prove that the offence was committed without his knowledge, or that he had the knowledge that some infringing activity, some copyright infringing activity is going on, and he exercised all the due diligence to prevent the commission of such offence. So the first is that he did not have any knowledge about the infringing activity, and the second one is he had the knowledge and he took all the due diligence, all the proper reasonable care which a person at some authority is expected to take care. So when he exercised all the due diligence to prevent the commission of such offence, and still the copyright infringement was done, then the person who tried all to stop the infringement activity, or who did not have the knowledge, would be exempted from the punishment, and he would not be given punishment under this section 69, although the company might be punished because the company has committed the act of copyright offence. So this is with this we come to today's end of today's session. So I hope you all are clear with remedies under copyright law. There are two kinds of remedies, civil and criminal remedy. In detail we discussed section 65 talking about civil remedy, and criminal remedy as well, from section 63 to section 69 of Copyright Act. Hope you all understood. Thank you very much. Have a good day.